let's say that you have 19 years. Let's say you have 20 years. Let's say you have 20, you're retirement eligible and you're in the Marine Corps. Okay. I represent an E8 retirement eligible going to an ADSEP board. And in the Marine Corps, you can't just submit your retirement because you are on administrative hold pending this ADSEP board. So even though you've hit your 20, you can't just walk away from it. You have to request that the administrative board be pulled and you're able to retire, but the command's going to say, sorry, not doing it. And so now you're on trial, essentially, at an administrative separation board with a brand new lawyer, no due process rights, hearsay is authorized, all things we've talked about. And if you lose, if there's a basis for separation and a discharge, I love the Marine Corps, an OTH discharge administratively reduces you to an E3 by operation of law. Not in the Army, in the Marine Corps.
Wow.
And
so you're telling me this E8 potentially could be an E3 with a stroke of a pen?
Yes. And not only that, that OTH, if they get recommended for an OTH, covers their entire service period, not just their current enlistment in the Marine Corps. So they're 18, 20, 21, 23 years. They can have 3 combat deployments. They could have pulled a burning body out of Fallujah and saved, and they could have a V device. Their entire record gets marred with an OTH and they're reduced to an E3. Oh, and by the way, if you're administratively separated, you're not eligible to retire, right? So it is a recommendation, right? So it's a recommendation that's done by the board, and it goes up to the Deputy Commandant of Manpower and Reserve. I think that's correct. MDR name. And they make the final decision. But in the Marine Corps, I don't think I've ever seen a case where they've disagreed with with the board. Because from there, the board makes their recommendations. It goes up to the commanding general. They block off and say, yep, we agree with the board. And it goes to higher and they're out. And so now what happens is, think about the value of a 21 or 20-year retirement. In particular, whether you're on blended or not, the value, I mean, you're talking $3-4 million, depending on, how much it's worth. And so, for example, if you are, think about it this way, if you are 20 years in, you started when you're 18, you're 38 years old, or you're 40 years old, and you said, I'm going to go to New York Life or MetLife, whatever it happens. I'm going to buy an annuity, which pays me $5,000 a month for the rest of my life with right of survivorship and a cost of living allowance. First off, no one would underwrite that. No one would sell you that annuity. And if they did, the discount rate would be so high, you'd be probably paying $5-6 million for that annuity. And that's not even including the healthcare and the TRICARE and all the other benefits. So what this boils down to are these ADSEP boards are no longer ADSEP boards. If you're retirement eligible, these are the equivalent of $3-4 million verdicts. If you lose, you are out an entire retirement, and you're going to be out as an E3 if you're a Marine. If you're in the Army, you don't get that reduction. That's a Marine Corps big green weed that they give you as well. So when someone calls me up and says, hey, I'm getting processed for an ADSEP for sexual assault, domestic violence, I was never prosecuted for it. I thought I was clear. I'm going to an ADSEP. What you have to understand is you have the most uneven playing field you can possibly imagine, where the scales are tipped extraordinarily against you. And now you're not just playing for your freedom. We're now dealing with a multi-million-dollar verdict, where, think about if you were suing a company, and this is civil litigation. Well, because they say, a preponderance of the evidence is the same standard in civil suits where money's involved. Well, if you're suing a company for a $4 million verdict, think of you can get depositions, you're getting due process, you're getting subpoenas, you're going to get a jury, you're getting experts, all things you're going to get if this was a $4 million verdict. And the lawyers are going to take 33% of it. And by the way, in that type of case, but here now we have a $2, $3, $4, $5 million verdict on the line, where you've got a second string attorney representing. Not always. I mean, I have seen the Defense Service Office do the right thing and detail more experienced counsel. I have seen that, so I don't make that blanket statement, but I've seen it the other way many, many times. In particular, if they don't request a more experienced attorney, no due process rights, and you're playing for a $3-4 million verdict. That's what we're seeing. And I'm doing this more over and over and over. In fact, I'm flying out to Bahrain at the end of July to do a case like this. I can't talk about it yet because it's ongoing, but it's significant enough where the client's flying me all the way to Bahrain and spending a lot of money and representation and travel because they realize as well as I do that this is a $3-4 million verdict we're fighting for. So that's the level of seriousness we take this as, and clients have to understand that that's what's at stake at these boards.